welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host, Ostika Das, and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website, www.livelaw.in. In today's episode, we are going to talk about the Constitution Bench hearing in the pleas against Section 6A of the Citizenship Act, gangster politician Mukhtar Ansari's son's plea in the Supreme Court, the top court's criticism of a Calcutta High Court judgment cautioning adolescent girls to control their sexual urges, and much more. So let's dive into the headlines. In a significant development this week, a Constitution Bench of the Supreme Court commenced hearings on petitions challenging the constitutional validity of Section 6A of the Citizenship Act 1955. The bench, led by Chief Justice D.Y. Chandrachud and comprising Justices Surya Kant, M.M. Sundaresh, J.B. Pardiwala and Manoj Mishra, heard arguments from senior advocates Shyam Devan, K.N. Chaudhary and Vijay Hansaria. Section 6A, inserted in 1985, is under scrutiny for its provisions related to the registration of individuals who entered India between 1st January 1966 and 25th March 1971 and have been residing in Assam. Devan argued that the section is discriminatory and arbitrary, violating the essence of the Constitution. He emphasized the need for a uniform application of the law across border states. He also highlighted concerns about illegal migrants in Assam potentially obtaining citizenship, while Chaudhary accused the legislation of favoring illegal immigrants over indigenous people for political gains. Chief Justice Chandrachud expressed the importance of allowing the government flexibility during crisis times. He also remarked that India had a very vital role in the liberation of our neighbouring Bangladesh. Hansaria argued that there are refugee policies in India for Tibetans, Chakmas, Rohingyas, Tamils, but none of them confer citizenship. That certain rights can be given, aid can be given, or vaccines can be given, but not citizenship, was the crux of his argument. On the other hand, Solicitor General Tushar Mehta argued for Section 6A's constitutionality, highlighting its limited applicability to a specific time and place. He asserted that addressing cultural differences justified Assam's unique treatment. Senior advocates Kapil Sibal and Indira Jaising also argued in favour of Section 6A of the Citizenship Act. Notably, the court instructed the union government to provide data on illegal migrant inflow to Assam and northeastern states after March 25, 1971. It sought details on steps taken to address illegal immigration, including border fencing progress and estimated timelines. It has also asked the union government to furnish official data on how many people have benefited from Section 6A of the Act. Stay tuned for further developments on this critical constitutional matter. In a significant ruling, the Supreme Court's Constitution Bench, comprising Chief Justice D.Y. Chandrachud and Justices Hrishikesh Roy, P.S. Narasimha, J.B. Pardiwala and Manoj Mishra, has affirmed the applicability of the Group of Companies doctrine in arbitration agreements. This doctrine establishes that a non-signatory company can be bound by an arbitration agreement if it belongs to the same group of companies as the signatory. The court emphasized the doctrine's importance in determining parties' intentions in intricate transactions with multiple entities and agreements. This verdict clarifies that not only signatories but also non-signatories can be bound by a written arbitration agreement if a legal relationship exists between them and there is a mutual intent to be bound by it. The requirement of a written arbitration agreement, in other words, does not preclude the inclusion of non-signatories, according to the Supreme Court. This ruling follows a 2022 decision when a 3-judge bench led by then Chief Justice N.V. Ramana referred the matter to a larger bench, recognizing the need for a re-evaluation of certain aspects of the Group of Companies doctrine. The Supreme Court has overturned a 2017 Gujarat High Court judgment that had quashed an FIR filed by the Gujarat police against businessman Mehul Chinubai Choksi. Choksi, a fugitive since 2017 in connection with a PNB loan scam, faced allegations in the FIR of criminal breach of trust, cheating, forgery and criminal conspiracy filed by the Ahmedabad police. The complainant, Digvijay Singh Jadeja, asserted that Choksi's company failed to return gold bars worth Rs 30 crores, violating the terms of their agreement and constituting a criminal offence. Choksi's wife, Preeti, was also implicated. The Gujarat High Court had quashed the FIR, contending that the complaint primarily involved a civil breach of contract and did not establish a criminal offence. The Supreme Court, however, has reversed this decision, stating that the High Court exceeded its jurisdiction under Section 482 of the CRPC by delving into factual controversies. The Apex Court set aside the High Court's order and instructed the continuation of the investigation. The Supreme Court has expressed disapproval of certain remarks made by the Calcutta High Court regarding the sexual behaviour of adolescents. The High Court, while deciding an appeal in a sexual assault case involving young adults, issued advisories to teenagers, specifically cautioning girls in their adolescence to control their sexual urges and in order to avoid being termed, and I quote, a loser in the eyes of society. The High Court's judgment, delivered in October, overturned a 20-year prison sentence for a young boy convicted of sexual assault under the POCSO Act. The High Court acquitted him even while citing the absence of provisions in the Act for consensual, non-exploitative relationships between adolescents aged 16 and 18. In response to the controversial judgment, the Supreme Court initiated a suo motu case expressing objection to the High Court's remarks. A bench comprising Justices Abhay S. Oak and Pankaj Mithal issued notices to the state of West Bengal, the accused and the victim girl. The Supreme Court deemed the High Court's remarks objectionable and a violation of adolescents' rights under Article 21 of the Constitution. Expressing its disapproval, the division bench also categorically said that judges are not expected to preach. Umar Ansari, the son of gangster politician Mukhtar Ansari, has approached the Supreme Court, expressing concerns about an imminent and serious threat to his father's life, who is currently incarcerated in Banda Jail, Uttar Pradesh. Filed under Article 32, the writ petition seeks the transfer of Mukhtar Ansari, a former MLA, to a jail outside Uttar Pradesh, preferably in a state governed by a party other than the Bharatiya Janata Party. Umar Ansari contends that his family members have faced persecution from the state and that he has credible information indicating a grave conspiracy within the state establishment to assassinate his father in jail. Mukhtar Ansari is implicated in the murder case of Bharatiya Janata Party leader I.N.D.I.A, among others. The petition highlights that 4 individuals accused in the murder have already been killed. Umar Ansari asserts that the alleged plot to assassinate his father is likely to be carried out for political gain before the 2024 general elections, potentially this month. The plea also references recent incidents such as the killing of Atiq Ahmed and his brother while in police custody earlier this year. Following the Supreme Court's decision last week to refer its 2018 judgment in the case of Asian Resurfacing of Road Agency versus CBI to a larger bench for reconsideration, the court has now announced the composition of the Constitution bench that will hear the reference. The bench comprises Chief Justice of India D.Y. Chandrachud along with Justices Abhay S. Oak, J.B. Pardiwala, Pankaj Mithal and Manoj Mishra. The Asian Resurfacing judgment stipulates that interim stay orders granted by high courts and other courts in civil and criminal cases will automatically lapse after 6 months unless specifically extended. The Supreme Court observed last week that as per this judgment, stays would automatically expire without a judicial review on whether they should be extended, potentially leading to miscarriages of justice. Other benches of the Supreme Court have also expressed reservations about the correctness of this judgment. According to a notification on the Supreme Court's website, the matter will be taken up for hearing after the conclusion of the Supreme Court Constitution Bench hearing of the pleas challenging Section 6A of the Citizenship Act. The Supreme Court has directed the Indian Army to establish a policy concerning the promotion of women officers granted permanent commission. This directive follows 2 significant judgments, the first in February 2020 in Secretary, Ministry of Defence versus Bhavita Punya, where the court deemed the absolute exclusion of women officers from permanent commission in the army discriminatory. The second judgment in 2021 in Lieutenant Colonel Nitisha versus Union of India held that certain criteria for permanent commission consideration for women officers were rooted in patriarchal notions leading to gender-based discrimination. Despite these rulings, women officers have often filed applications asserting discriminatory criteria in promotions from Lieutenant Colonel to Brigadier ranks. During the recent hearing, Chief Justice Chandrachud and Justices J.B. Pardiwala and Manoj Mishra addressed concerns about the pay disparity for women officers even while holding the same rank as their male counterparts after promotions. Attorney General R. Venkataramani informed the bench about ongoing deliberations at the Army headquarters to formulate a policy for women officers' career progression to be considered by the selection board. Acknowledging this, the bench stressed the need to complete the policy formulation by March 31st, 2024. The Allahabad High Court has issued a stay on criminal proceedings against Samajwadi Party chief Akhilesh Yadav and Rashtriya Lok Dal chief Jayant Chaudhary before an MP-MLA court in Gautam Budh Nagar. The charges relate to alleged violations of the Model Code of Conduct and COVID-19 norms in 2022. The accusation suggests that in February 2022, Yadav, Chaudhary and approximately 300 to 400 unidentified individuals were travelling from Luharli Gate in Gautam Budh Nagar to Noida. During their reception by co-accused persons, a large gathering ensued, leading to the violation of COVID-19 guidelines. Both Yadav and Chaudhary faced charges under the IPC and the Epidemic Diseases Act, prompting a summons from the local court. The instant legal challenge seeks to contest the summoning order and the entire criminal proceedings. The Punjab and Haryana High Court has quashed an FIR against former Punjab Chief Minister Charanjit Singh Channi relating to an alleged violation of the Model Code of Conduct during the 2022 state elections. Channi, along with late singer Sidhu Moosewala, are facing charges under the IPC for campaigning in the Mansa region beyond the prescribed time limit. During the Punjab elections in February last year, the Deputy Commissioner of Mansa had issued an order enforcing Section 144 of the Code of Criminal Procedure, stipulating that the election campaign must conclude after 6 p.m. The complaint alleged that Channi, along with over 400 individuals and Sidhu Moosewala, continued door-to-door campaigning after 6 p.m. on that day. An FIR was subsequently filed under Section 188 of the IPC for disobedience of an order duly promulgated by a public servant based on the written complaint of the Deputy Commissioner. The Kerala High Court heard a plea this week urging the Government of India and the Election Commission of India to restrict 26 opposition political parties from using the acronym I.N.D.I.A for their political alliance in the upcoming 2024 parliamentary elections. The acronym stands for the Indian National Developmental Inclusive Alliance. The petitioner contends that this term is employed to foster political animosity, deceive and polarize voters. Notably, a similar plea was filed before the Delhi High Court, where the Election Commission stated its inability to regulate political alliances under the Representation of the People Act. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audiovisual format, we need your support. So don't forget to do the fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host Ostika Das, and I will see you again next time.